I have been given a daunting task of dealing with a very, very sensitive and the most relevant issue that faces us today, namely the POSH Act. First, can I just request in the audience, how many ladies are there? Can you just put your hands up? I just want to see the percentage. Okay, so that's quite a significant number. Excellent. I will introduce the panel, but before I introduce the panel, I thought it's important to set the context and tell you a little background about the statute, the problems it faces, and the journey that the statute has traveled and where it has become. So let me first say this. This is a statute that has been there from 2013. Unfortunately, you are seeing the rigors of it or the implementation of it today because very many companies, very many corporates, for some reason or the other, did not implement the statute, and implementation of a statute is more important in terms of what it is. It took the Me Too movement for many of the corporates, and I, outside of retail, get a 360 degrees in terms of seeing the overview of corporates and corporate etiquette and culture. And I must say that there has been quick haste in people at least now inquiring and understanding the statute. So, to set the context, let me say this. 2013 is preceded by what happened in terms of the Vishakha committee. A lot of people misconstrue that the statute is nothing but the Vishakha committee because that's a misnomer. That's not. The statute has been implemented after a lot of deliberation in Parliament. The Vishakha committee is passé. It's in a sense prior to that in terms of the guidelines that got framed. This statute, to my mind at least, and I'll take views from the people in the panel as well, unfortunately, being a very simple statute doesn't have teeth. And I think the relevance of this statute is in terms of execution, implementation, and the consequences that the statute must have. So we will debate that in a later part, and this is how we plan to do it. I will have Pulin come in and give a little bit of introduction in terms of the journey that happened historically and 2013, and then we are in 2018, including the Me Too movement. So that's going to be Pulin's part of the discussion. The second is, I want Jyothi then to deal with the more relevant 2013 and 2018 in terms of what her experience is. And I must put one caveat. None of the people here, except myself, because I can sort of disclaim it far better than most others can, are expressing any views of their organization. They are here personally speaking about the statute, so I don't want anybody to feel that this is a view of A organization or B organization. That's not the purpose. This is more of an academic discussion, and therefore please view it constructively in terms of, rather than having a view that this is the view of X, Y, Z or company. I don't think that's the purpose and that's not the intent. So Jyothi is going to deal with more in terms of her experience and the consequences in terms of the statute, the difficulties that are faced. Then we have a very interesting, for Prasad. I think Prasad is going to speak more on the hygiene issues. So it's really the nitty-gritties and the nuts and bolts of the statute. It's a small statute, not many sections, one rule. So I think Prasad is going to give more things in terms of the nuts and bolts and the hygiene issues related to the statute. Mr. Shetty has the more daunting task and the more important one, that he's going to be dealing with the challenges the statute is facing. One of the things that we were discussing upstairs right now is what happens if there is a police complaint and parallelly in the statute. So what are the challenges that the statute faces? Jyothi also raised a very important question that what happens, in terms of parallel litigation, but also, is the LCC really working? What is happening at the bureaucratic front? So those are some of the things that Mr. Shetty will deal with. Then I want Arpita to deal with really the issues, and please feel free to come in. So what are the issues and what are the challenges that the statute faces? And of course, then we sum it up and close it with solutions on the statute. So that's really the dramatis personae. That's really the form and manner in which we are going to make this discussion. I just want to say two things before I start and hand it over to Pulin. In the last 3 months, and I must say this with a sense of responsibility, that I have dealt with more than 50 to 100 cases on the Me Too movement. And it has been very, very challenging as a law firm. There are families that are involved. There are individual careers that are involved. Also, there are people who are suffering and who've come out in the open, and that's the better part of all of this. It's very difficult for any corporate to take A position or B position, because as a corporate and more as a lawyer that I see it, trying to keep not only neutral but trying to see that the perpetrator is out of the organization or has remorse for what he has done is important. It's challenging. In fact, I must say that the first matter that went into the High Court, which went before Justice Kathawala, was a matter that I tried to settle and I'm still trying to settle. It's all in the public domain. It's challenging when a lady is called upon to file an affidavit in court, which she doesn't want to file, but she's called upon to file. And then to seek a redressal on that, because nobody wants to come in the front and mudsling. I have seen criminal complaints of very, very celebrated people being filed and then withdrawn, and then yet, in fact, I'm dealing with a very interesting case right now, where after filing a police complaint and withdrawing it, the alleged victim has gone out in the media and again discussed about the incident. Now, therefore, what is the recourse that a person has? What's the purpose of the statute? One of the things that all of us must remember is, while this is a 2013 statute, 354 and 354A, which deal with sexual harassment, has been on the statute books for the longest time. So we must give it to our lawmakers very many years ago who even thought of 354 and 354A. Also, please understand that sexual harassment is very, very big. It's not just in the retail industry, it happens in our industry, it happens in every walk of life. Outraging the modesty of a woman is what the woman feels and not what you feel. So therefore, tomorrow if I'm putting my hand on a lady's shoulder, if her modesty is outraged, then she well has a cause of action. And it's only for her to decide that. And the burden, in a sense, is on the complainant to show that. So that's the context. And I'm glad that in a democracy as vibrant as ours and as young as ours, we have the ability, and this is based on the touchstone of our Constitution, Article 14 and 15, is the principle on the basis of which this statute got enacted. The Law Commission also implemented that in terms of equal right to equality and a woman's right to equality. And therefore, while this is a beneficial legislation, it's also legislation that is very important. I think it's important that nobody is intimidated, nobody misuses the statute. Unfortunately, any beneficial legislation also gets misused over a period of time, and that's the negative part of the statute. So in this backdrop, I'm going to hand it over to Pulin. Pulin, I'd like you to give the context in terms of the journey that the statute has traveled, and from really from the early 90s to what it is. Please, over to you, Pulin.
Thanks, Ameet. Good afternoon. As we all know that, in our system of legislations, it's most of the time we have seen that it is all knee-jerk reaction of the legislature out of some incidents or the other, and the law is placed on the House. But in this case, if I relate back the issue, it goes as far as back 1992, when the Bhauri Devi must have heard about that case in Rajasthan. That has happened. There could be some difference of opinion that it is not exactly the case of POSH, but there are people who still think that this is again a case of POSH but nothing else. So that starts in 1992, and then after that we all know that Vishakha Guidelines come from the Supreme Court in 1997. And then after that we have a law in 2013. So if we look back, the knee-jerk reaction, that hasn't happened in this case, whereas the issue was prevalent. maybe that was hidden behind something, some kind of, hesitation or the fear psychosis in the mind of the people who are really victim of this kind of, activity or act in the organization or a workplace. But it took so much of more than 20 years to come with the law now. But something is better than nothing. And then we have law at the moment in place, which specifically deals with the issue. But as you said, there are hundreds of cases, Amit, you have been handling, and still, of late we have seen the movement, which is widely known as Me Too movement. People have started coming out and speak out. At least something is happening. But yes, that has its own impact on the life and liberty and kind of reputation or whatever of an individual. But it's good that people have started coming out. But again, what kind of, lots of things are moving to the, as Amit has said, that, settlement is the preferred mode of, kind of solution to the problems. If the settlement is the approach, then also, this has to be looked into how it evolves over a period of time, because the law is made and how the law gets settled finally. Because the case laws and the judgments and everything will come into play, because being a common law country, the law has to be evolved, a lot of interpretational issues will be there. Now the question is that where are we standing today? Look at the kind of, movement which in 2018 we have, after 21 years or more than 20 years of history, where people have started thinking about, kind of safeguard at the workplace against the menace of the sexual harassment. Now we have a law in place. Law has got strength in 2018. Although it was there, the obligations have been cast upon the corporate to make the internal IC, and for unorganized sector we have LCs. They have their own responsibilities, but look at the, kind of after that remedy. If somebody is not satisfied with the IC, kind of finding, then the appellate tribunal, and appellate tribunal is the labor court. So finally that is going to happen, and then after that you have the High Court option to go into that. So with this kind of development and things are now coming up, I do feel under the circumstances that in times to come the law would evolve and it will shape up more effectively so that the redressal of the grievances are addressed in an appropriate manner. Of course, it has taken more than what time it should have been taken, because this is something which was happening for many years, and now the things have really come up so strongly because of some courageous people who are coming out now. This is what this is how it has not a big history behind this, but yes, this is how it has evolved. With this, I think we'll more interact when the discussions go on. So hand over to Ameet again and to take it forward.
Pulin, in 90s, there was a matter. You want to discuss a little bit about that? The case?
Factual, there's no point in going into the facts of the issue, because I didn't really discuss over the facts, because everybody knows about the fact.
Right.
That has some political angle also.
Sure.
And there could be many, differences of view. But overall, overarching, if you look at, if we have to, as a legal person, or kind of if you look back the historical background, that somehow starts from that point in time. And if you have something connected to that, then I would be happy to answer.
So I think you set the context well in terms of how 2013 happened and the Vishakha committee. May I just ask the audience one question? How many people have not implemented this statute? Can you please raise your hands up? I mean, you'll be worried to raise your hands up, but are there anyone in this room who's not implemented? So that's good. That's a good answer. Great. So, Jyothi, over to you. I think in terms of the journey from 2013 and even before, and the experiences that you're having, both at the ICC and the LCC end, if any, I think that will be very relevant. Also, maybe you want to stress upon from an organization perspective, because there are a couple of questions that people keep asking, that what happens, is a workplace defined and to mean any subsidiary? Is every workplace distinct and different? Is the implementation of the number of employees, which is the restriction on the number of employees, what happens? And of course, who's an employee? Whether a casual employee is covered within the definition of employee, and therefore who has recourse? So some of your experiences on that, Jyothi, would be helpful.
Sure, Amit. Well, I would again go back to 2013. Well, before 2013 itself, Vishakha Guidelines were already being implemented by many corporates. As you all know, 1997 was the time when this landmark judgment of Vishakha came in. And all the employers were mandated to set up a redressal mechanism to address the sexual harassment complaints in the organization. And it was not really happening. You can see from 1997, it took us so very long till 2013. But in our organization at that point in time, we had already formulated a gender neutral policy, which was being really advocated, and it was also the training was given to all the employees about it, the awareness about the gender neutral policy that we had. But when the 2013 law came in, we made it, meaning at least as a lawyer, I had to tell them that, look, we may have a gender neutral policy, but under the 2013 Act, we need to look at it separately in terms of having the redressal mechanism as required under law, and and also create awareness about the complaints committees, what we call internal committees, to the organization. So that's how the journey started, and we started. Of course, we had to set up the ICs across the organization, and the second thing was to create awareness about it, and also the training to the IC members. So most often when I spoke about it, the question that I used to always get from the participants was, isn't this unilateral or isn't this one-sided? Why are we having a law? Why are we, like when we already have a gender neutral policy, why are we now trying to kind of narrow down the scope of this and try to kind of make it like one-sided? Are you trying to say that there can't be any instances of sexual harassment by woman to a man? This was the question I think I would have answered zillion times. This is a question I faced and I had to answer. I had to tell them that, look, you can look at the very title, and I had to give them the background, what really went on from 1950s, the Constitution came, but 2013 we're still talking about equality for men and women in a workplace and situation. And though IPC was there, how difficult it was for the women employees to kind of air their grievance in a police station about their personal instances of sexual harassment, and why it was considered, everybody could relate to that. It's indeed a taboo. That's how people would relate to that. Nobody would even go forward to file a police complaint. So this is a case when actually it has come in to protect the women against such, harassment cases in a workplace, and it is the law that mandates the employers to have it. But again, the people would say, come on, like the Dowry Prohibition Act, this also is going to be yet another act which is going to be highly abused. Well, I had to tell them that, look, there is some check and balance in the act. Well, there is a provision in the act which says that, if there is a false complaint, the IC can also take action against her in terms of it could be even the termination of the very employee if it is a false complaint. So there is some amount of balance in the act, and I had to tell them that. Okay, and of course, coming back to how many instances of false complaint could be there, well, I think that is another topic which I think Arpita will touch upon, and we will all pitch in with our views. But again, moving on to other issues, like coming to the implementation of the act, most often the participants would wanted to know, like, what is this workplace definition? Why is it just the four walls of the office where we work in? The concept, the extended workplace concept that you see in the act is something that you really have to apply to all such instances where the meetings or whatever the employment related transactions are connected with work. It could be a meeting, you could be just meeting in an off-site place in connection with work. It could be an outside conference. It could be your own buses. which are used to ply the employees, right? So actually the definition of workplace can be extended to any length as long as it relates to employment, right? So this had to be explained, and it's very difficult for people to actually contemplate it. Because, and that is where, a lot of confusion happens as to, hey, like I know my colleague, we go for coffee, and, what if something happens there? Does that amount to work? Is that a workplace? But then, this is something that I'm sure all of you would have faced this challenge of interpreting, the definition of workplace. But yes, it has to be looked beyond those words to see where, the employer and the employee relationship. It's just not the employer-employee. It could be colleagues also. So if you're meeting in connection with the work of the organization, and that again becomes an extended workplace. And coming to who could be the complainant, again, that was again, we had to explain it. Who all could be the complainant? Most often people think that, okay, if I am the organization, the employee of the organization, yes, I can complain. Hey, but what about my friend who just came in to meet me? What about the visitor who just came in? What about the consultant who just came in for a while to give some advice or probably work on any assignment, right? And what about housekeeping, right? What about your, the interns, all of that. So if you look at the law, it covers all of that. So complainant, it could be even the customer. So we had to tell the people that, look, even if it is a customer who doesn't even buy a single penny worth goods, she still walks in, and she suffers an act of sexual harassment. Yes, she is a complainant. An intern, as I said, all of these can become complainants. But then again, the counter question would be, like, who can be the respondent, right? So most often, if you look at it, like a committee, an internal complaints committee, of course, has to conduct an inquiry, right? And of course, it's clothed with the powers of, like, it's almost a civil court. You can actually, call for the evidence. You can conduct an inquiry. You will actually allow the parties to conduct, examination, sometimes cross-examination. And of course, there's no hearing as such, but you do the findings. It's all something similar to court proceedings. So where you see that, if it is a respondent is in the roles of the organization, that is the accused, you can actually pass pass orders against him, or any findings can be made against him, recommendations can be made, because you can look at it under the law. IC has the powers to give certain interim reliefs. Like, you can perhaps order for transfer of the accused, if it is really causing disturbance to the complainant. Or it could be the transfer of the complainant
so,
also.
Sorry, just to interject, in your experience,
yes,
if there is a complaint, and there is a prima facie view that a committee forms, the ICC forms, what have you seen? Have you seen a person's employment terminated? Has he been asked to resign? Or actually then there is a reference made to local authorities? What is, in your experience, happening in organizations when in fact there is a prima facie view that the ICC forms?
No, the local authority doesn't come into picture here in a corporate setup. It's ICC.
So what are corporates doing? Are corporates only terminating the employment? Are corporates asking them to resign? Or are corporates saying that, all right, you Mr. Complainant, you Miss Complainant, go ahead and go to the police? What are you seeing as corporates are doing?
Not really. So it's actually, it's a complainant. We often see that the complainant often comes up with a written complaint when you see that. And then even before the notice is issued to the respondent, even under the law, there is, you can ask the complainant what she wants. So that's a settlement even before the proceedings start.
Are you seeing monetary settlements, apologies, or what is the nature of settlements?
Yes. So of course, so the monetary settlements, even you cannot do that even much before the things happen, because the law prohibits doing that. But definitely there is a provision, like, we definitely ask what would the complainant want. But in my case, what I see most often, the complainant just wants a word of apology from the other person. And most often, it may not be as grievous as it is, but she's hurt by a particular activity, or it could be just it's a word, or it could be, like a remark against her, something like that. So in a small instance where she would want to kind of really exercise her right to air her grievance, And she says that no, apology is just enough.
Can you also throw some light for the benefit of everyone? I'm sure most of them know. The constitution of the ICC. What are the ingredients of that?
Yes. So ICC, again, if you look at it, the chairperson has to be a very senior member. And of course, the constitution, the number of members, the male and the female members, it says the number of female members has to be minimum 50%. And you need to have somebody as an external member who is like, is in an NGO or who is, associated with women movement, and somebody who has knowledge of this and things like that. So generally what we do is we often ensure that men and women are equally represented in an ICC, so that, at least the complainant and the respondent get a view that it is not there is no prejudice against them.
Jyothi, one short summary. Is POSH a good statute, and is it being implemented effectively? What is your view?
Well, I would say that the intent matters a lot.
I'll take the questions. Just give me a second.
Intent matters a lot in terms of implementation of POSH. Well, I feel, you go with a microscopic examination as a lawyer, you will find some 100, mistakes in the drafting perhaps. But I would rather say this act has to be looked at it from the intent point of view in terms of implementation. Well, I see that lots of corporates have been really taking this seriously, and they are implementing they are setting up the POSH, they are also implementing it and creating a lot of awareness about it.
Excellent. So, Jyothi, thanks very much. And I think that sort of is the sequitur to the next thing that Prasad is going to do. Prasad, it's a small statute, very few sections.
Yes.
What do you feel are the safeguards or the hygiene issues that a corporate should have in terms of better implementation of the statute?
The first thing, as you said, that it's a very simple statute that way. It's constructed simply. The first thing is to make sure that you have an IC committee in place, and it is valid at all times. So many times what happens is it's also sometimes a victim of attrition. So if some people who are on the committee go, you need to have new people appointed, and you just can't get into a technical breach for not having a functional IC. Not that every time there is going to be a complaint, but whenever there is a complaint, there has to be a functional IC. So ensuring that there is a functional IC is an important assurance that the employers have to have. Otherwise, the whole implementation can get very difficult. In fact, there was one, the famous Air France case is finally on that if the IC is not correctly constituted, the High Court at that point of time, sent it back for a fresh review of the case, etc. So I don't think employers would want to get into that. So have a functional IC is the first compliance that you need to do. Second compliance is obviously not that law requires you to publish a policy per se, but it's always good to publish a policy in a manner that your employees understand. So you can use pictorial presentations, you can do do's and don'ts, you can put lots of safety guards, and make sure that you're communicating with your employees in terms of what is it that as an employer where you stand and what is it that you do not tolerate. So you need to bring this clarity through policy, and it's easy to, shall I say, publish or popularize a policy than to popularize a law per se. So because law is a complex piece of legislation, difficult to explain, understand likewise. So you can simply put as to what this translates to us in terms of POSH Act. So the second thing is that. So these are the two basic compliances. After that, there is one more compliance that companies have to do, and I think many employers forget to do it, is there is a return to be filed under this act, and that annual return is a must. And now, probably a month back, now, the new mandate is also to publish the POSH statistics in the annual report for the companies. So that is going to be another governance requirement that is going to come. So these are three things that are required to be done from the standpoint of pure compliance. so that you as an employer are not at a non-compliance of a framework. Not that having a framework does necessarily mean that it is an efficacious framework, but not having it is a gross breach. It's like, if you have a driving license, you may not drive well, but not having is a clear breach. So you will have to, ensure that this basic compliance is in place. The one thing that, after Vishakha came in, and this law also brings, is it fixes a responsibility. As Ameet was saying, 354A and B have been there for ages, but now there is a role for an employer. So you have to ensure that you are the one who is arbiter of the peace and social order in your organization, and are ensuring that takes place at all times, and you have a mechanism to redress. Now, therefore, employer must ensure that even if there is a perpetrator in the organization, the employer is not seen as one who is directly or indirectly abetting or encouraging the perpetration and causing bad name. Nowadays media is quite tough, so you better would not want to err on that side, and that's also actually a part of compliance that we have to ensure. And there is one thing that what constitutes sexual harassment is quite clear in the law. So I don't think there should be any confusion on that. It's basically two ways. One is the physical and the non-physical. And of course there is another thing is creating hostile environment. So these are three things. One thing that we, especially in the context of Me Too, I want to say is that the law prescribes 90 days limit. That means the complaint has to be filed within 90 days of the instance or the last instance. So therefore, if some old Me Too cases come up, I'm not sure how organizations will
I'll
look
tell
at
you
it.
with some experience. I had a matter in court, and the statute of limitation just goes out of the window. I think judges are more indulgent, committees are more indulgent. Yes, there is a prescription of 3 months as a period, but I can say this, that because the movement is so solid, we are seeing for the first time that even judges are indulgent, where they are saying that, all right, it doesn't matter if it's 1 year old, it doesn't matter if it's 2 years. The question is, how does a committee react to that? Right. And I think one of the most important questions I had for you, because you're dealing with the nuts and bolts of the statute, can the committee, and I think this is very important, initiate action absence a complaint, suo motu? Does the committee have any power or authority to actually do anything? Suppose if there is an issue, to suo motu, because that's the challenge that every ICC and every corporate is facing. The question is, aap kya kar rahe ho? So, can a committee on its own take an initiative absence a written complaint?
Well, in the scheme of law, the answer is no.
Correct.
Okay,
so that seems to be the
Yes.
issue, and that
Yes.
in a way is the statute, and that's what the POSH. Sorry, you have a view, Pulin? Yes. Yeah.
Actually,
This is a very
as long
controversial
as
subject, so I want to-
the legal system does not do away with the evidences and the affidavit which you have quoted just before in your inaugural kind of introduction, as long as you do not do away with the cross questioning and kind of evidence, leading evidence, that is not possible, because victim has to come up and she or he has to depose.
Therefore, my question really is, the ICC today cannot function absent a complaint.
No, it cannot, because ICC is basically a facilitator in a way that, it's an investigating agency of an organization where, that is a primary responsibility has been cast upon them to investigate and report.
But then what good a statute is there if you have an ICC, they don't have teeth, and they have to wait for a complainant who may never come?
Yeah, that is the irony, because we have law, but still we are, in a process of setting up and shaping this law, because law itself is not sufficient. Because what happens to the social kind of status of a victim. I mean, how
Pulin,
does...
you were
yeah.
saying something? Pulin, I don't mean to cut you. You were raring to say something. So
Yeah,
I'm
so I was trying to say
I'm conscious
that,
there are two women on the panel, so I need to hear them more.
no, I mean, I'm not seeking liberties here as a woman, but I mean, what I have seen in my experience, there could be times when, let's say, one or more members of the IC have evidenced something happening, and they themselves come up and complain that, although I am not the recipient of the behavior, but I have seen this happen in front of me. Something is happening to a team member who is at a loss of either confidence or, or whatever, and is not able to come up.
So actually, are you seeing ICC members suo moto then?
I have seen specific cases where members themselves have come up and said, yes, I have seen this happen. So, let's take this up. And very often, the junior most employee who's been at the receiving end have been given the confidence and that support that, come on, speak up, we are with you.
That's interesting. Both of us had a very different view.
Yeah, there is something that I want to respond to is what happens is, unlike in a, say, a judiciary, where there is somebody who's prosecuting, there is a judge who is going to listen which side is right or wrong or whatever, and there is somebody who's defending. In IC is itself, has a responsibility to go into the facts, and they may not be really the facts of the prosecution. They could be beyond that. So there, to that extent, the initiative IC is, I think, is mandatory. However, the problem is if the complainant herself does not come forth and say, "Thus, I am an affected party," because the key to the entire statute is unwelcome. So she has to stand up and say, I mean, I cannot say what is unwelcome on somebody else's behalf.
Exactly.
So, so that is
Jyoti,
the...
you wanted to say something.
I think I'm just continuing what he's saying. It has to be, as you, again, Ameet, you said very clarified at the beginning itself. So it's the, it does not amount to sexual harassment as long as the woman doesn't feel it so,
Yep.
right? So if woman has to, she has to talk. So she has to do. I can understand that if you see a situation where she's undergoing such an instance of sexual harassment, you can definitely encourage her to come forward and file a complaint. At best, you can do only that. But then she has to stand by her complaint, and the complaint becomes a basis for continuing the proceedings.
So,
Yeah, just to answer precisely, Amit, the IC's responsibility is to report the matter, not the prosecute. So for prosecution, victim has to come forward. So reporting is okay. I mean, IC can report on behalf of the victim, but as far as the prosecution of the complaint is concerned, the victim has to come forward, and that's it.
So keeping that now, I'm going to hand it over to Dinesh, Mr. Shetty, in terms of this, the context, the challenges. Because I think one of the largest challenges that this statute faces is not just implementation, but the ability where does the statute really have teeth? Can it really prosecute? What is it that the statute can really do for the victim and against the perpetrator? And so therefore, I think you can illustrate a little more on the challenges of the statute.
So let me just touch upon the last bit of point we discussed. Unfortunately, law even doesn't recognize the oral or anonymous complaint. There is no provision in the Act that you can make a oral. But certain companies do, acknowledge oral submission. They get it done through HR department. There is somebody who helped them to draft a complaint, which is more in a best governance perspective. But unfortunately, law doesn't permit that. Now coming back to the challenges, let me come couple of points on these challenges being faced by the employers. Most of these, of course, the big firms or companies or a large group have their own set of people, expert people who are lawyers who are supporting the entire cause of this act. But in case of small companies, the lack of awareness is the biggest problem. Even at a smaller companies, people doesn't know what constitutes a sexual harassment. They still feel that it's only physical contact, but they're not aware that lewd jokes or some inappropriate behavior constitute a sexual harassment, which is a very sad part. I think over the period, thanks to Me Too movement, people are now more aware of the sexual harassment part and getting into the process and how to go to a complaint, even to external authorities or internal authorities. The second is the lack of confidence in the judicial system. it's both the internal as well as the external. Most of the companies, especially from the junior level, they feel that once you file the complaint, the HR department takes over, and they set up a committee, and sometimes they feel that it's all internally managed. So they don't have enough confidence in putting a written complaint to the internal ICC, especially when there is a very strong systems and governance. And this is most relevant in a mid-scale or small companies. And the third is generally the company faces dilemma is what is inappropriate behavior and the sexual harassment. So I'll give an instance which I have come across 3 years back. One of the senior most employee was, one of the her boss, one of the female employee complained against a reporting boss, saying that he looks in a different manner. So we are in a dilemma whether is it actually sexual harassment or is it a normal complaint. So as a good governance, we took up to the ICC committee. ICC committee went on to the inquiry. It finally found out that he has a vision problem. There's nothing wrong with this. It's nothing to do with the sexual harassment. And unfortunately, the lady took a different stand. Then came back and said, no, he had, had a physical. He touched me when I was in one of the Mumbai marathon. So they took a different stand. Of course, we took a very measured stand. We ensured that employees also taken care as well as the complaint was acknowledged. So we took a medical report to confirm the vision issue, and also we ensured that the seating arrangements changed in such a way that it doesn't affect the people working around him. So this is a very dilemma faced by the employer. Is it really sexual harassment or is it a normal complaint? And coming back to the statute part, of course, what we discussed is whether parallel proceedings can go on. I had similar instance where we closed the investigation. There was a recommendation to stop the increment. There was an apology letter. Despite that, the female employee went on to file a police complaint. Of course, police started their investigation. It's finally settled. The question is whether can be done parallelly both the proceedings. Ameet confirmed that legally there is no bar. Mutually exclusive, there's no bar, which is the stand we are taken in my case also. So these are some of the challenges. Coming back to the particular retail industry, I think one of the likely scenario where we are going to face is how to manage the franchisee sexual harassment complaint. Because technically they're a different company, different entity, but a brand has a lot of reputations. So if something happens in your franchisee operations and someone want to take on to the brand, they really can use this, to spoil the brand of the company.
But isn't that answered in the definition of employee and workplace? Because
no,
it doesn't matter whether you're a franchisee or not. So long as there is a workplace and there is an employee, whether you license a brand and whether you license a franchise, you're liable for it.
No, Ameet, I'm talking about the employees of the franchisee, not employee of the company who goes to the franchisee operation. So
employees of the
franchisee. Because a lot of retail industry moving towards the franchisee model, which is the normal.
So that's interesting.
But question is whether, of course, some big companies do a awareness program even for the franchisee employees and franchisee owner. But question is how to, in a large scale of business, how to manage the franchisee operation, how to make them aware of the sexual harassment, how to control the reputation risk, which is a big thing. It's a big challenge.
So there are two things. One is the brand itself.
Yes.
Because that is open to scrutiny and challenge in an action for defamation even otherwise.
Correct.
Because somebody can say that, look, this has happened in X brand and this is the franchisee.
Correct.
Obviously, the employee has recourse in its workplace, on her workplace, whatever they want to do.
Correct.
But the reputation of the brand can get
damaged.
And that's the consequence.
Yeah.
I don't think you can insulate that
Absolutely.
in any form or manner. So that's interesting, Dinesh. So you've given us a perspective in terms of challenge, in a sense, challenges. Is there anything that you
one of the last point is the most difficult part is writing a report, investigation report. If you have a lawyer in your ICC committee, 50% problem is solved. But if you don't have a lawyer who is an NGO, non-lawyer, or an HR department, then the most challenging job is to drafting a report, especially when the matter goes to the next level, because your report is going to get challenged. In one of the cases which I handled, again, the report was challenged before the police authorities.
Yes. So I have a solution for that. Yeah. Gautam, please circulate Naik Naik and Company's name to all the retailers and make sure that they contact us.
I hope you're also committing some huge discount.
Absolutely. No, on this, I must say, in many matters, I'm not even charged. So we've been very...
And that would also save us
appreciate.
from the, because I have always a question with respect to the constitution of the IC. Isn't it a biased constitution? Like, you know, we are under obligation to hire one person on the board. I mean, I see.
No, then that's a separate issue, Pulin.
Yeah.
It's a challenge of the statute which nobody has done.
No,
So
not
I'd
challenging.
like-
It's a question of conflict of interest, because you see 3 out of 4 are from the organization itself.
Yes.
One is from probably from the NGO. So this challenges the very status of the, you know, biasness of the IC. That is one question which I leave it for
For the
you know,
audience.
for the audience and for me also
So
to, you know, understand.
We're running a little short on time.
That is one. Another question which I leave it to the audience is that, you know, we all talk about reputational loss. Is it for the reputational loss, all this hullabaloo is for reputational loss, or the justice to the victim? So these 2 questions have to
So
be
I'll
considered.
answer that right away. I think what Dinesh was trying to say is the following. I don't think, I think one is the action in terms of a wrongful claim which can lead to reputational loss. The other is actually justice being met out for a victim versus a perpetrator. And I think those are completely different things. Arpita, I think you have the last word now. I have a very, and I want a very unbiased view in terms of what do you feel? Is this a statute which allows misuse? Is this effective? What are your thoughts in terms of the statute? And whether the statute was there on the statute books or not, what's the difference that it's making today?
Yeah, so I don't think I'm of the view that I would want to blame the statute, no. I think if it is working or not working, the reason lies with us. And that brings me to some of the issues that I have observed over a period of time that I have been in, you know, this role in various organizations. So first and foremost, most organizations, and I'm not going to name any, have a typical tick the box approach when it comes to this topic. अच्छा ये भी करना है, उसका एक form भरना है, उसका एक MIS disaster है, we have to fill that. You know, that's the approach. And pardon me for being blunt here. And so the first issue that I see is that, especially in retail, when issues come up at the store level, somebody who's the junior most, who doesn't even understand, you know, for whom English is not the spoken language, for whom it is vernacular, for whom it is a different set of cultures, how does that person report? So he or she reports into someone who is, let's say, the store manager, or then the local HR. More often than not, my experience is that they try and sort it out between themselves. Let this not go up. Arey usne kuch nahi kiya. It was like this, it was like that. Right? It never reaches the central office where, let's say, I sit or you sit or others sit. That, to my mind, is the foremost problem. And then
Is very important.
so I'm coming to that, and how we you know, overcome that challenge is by creating campaigns of awareness, and I'm kind of happy to say that in many places now we are actually running the training programs and campaigns even in the local languages, you know, which the store people understand, because often in the feedback forms call out that I didn't understand. So that was the sort of you know, subtext to that first issue. And then the second issue is that, and it is to my mind one of the larger issues, that there are times, and I have seen in my life at least 2 or 3 instances where the perpetrator happens to be part of the IC. And then the organization is really in a 22. It doesn't know what to do. It is someone very important or considered important either for the business or for the reputation. It is either, you know, head of some department or the other. What does it do? And more often than not, companies fumble. And they look for answers. And I know of cases which still stand, you know, remain unclosed or open yet. And I've had colleagues who have in the Me Too movement reported these out, called out the employers.
Do you see promoter, I always say this, and I can be quoted, do you see promoter involvement in the ICC? Are you seeing that at any level?
For me, I haven't really worked in a lot of closely promoter-driven companies, barring, of course, FabIndia, which is more of a closely held group. But I didn't see this challenge in the larger board-driven organization.
So you don't see the board, because I can say this with experience that I have not seen in the last several months. In fact, the board seems to be very, very distanced and very, very this thing from the ICC, because nobody wants to be foul of a statute.
Correct.
And
Correct.
this, so I think that is something certainly that has changed. I don't see an Indian promoter. I don't see a board, and particularly if it's a listed company, and even if it's an unlisted company, even where you have private equity in that company, I think they've become even more cautious, because internationally it's a big issue.
Yeah, it is a big issue.
And not just internationally, the awareness is so large. So therefore, if I was to ask you this, I think the statute is here to stay. I think it has made a dent. People are coming. And I think one of the things...
I'm sorry, I'll respectfully disagree on that bit. I'm not sure the statute had made a dent. It is some of us who have made the dent.
No, fair enough. I stand corrected.
Right?
I agree.
So the
please
statute has
put
been
your hands
there.
together for that. I think
No,
that's very
statute
important.
has been there. It is people who have made a dent, and
Yes.
it is people who have made others to listen. And whether out of fear or out of favor, people are now, willy-nilly having to listen. I have just one last issue that I want to bring out here, which is the issue of frivolous complaints. And there are occasions when, and in my mind, sexual harassment complaints being frivolous largely are actually HR issues which get colored as, sort of get laced as a posh complaint. In my experience, it has all been primarily HR issues.
Excellent.
That I was promised this and I was not given this. So it was because, he asked me out for coffee, I didn't go. So, and when we investigated, when we looked at, evidences, it all kind of, things do fall apart. At the end of the
So can
day.
I say there are two sides to it, and I think you put it very well. One is, what do you do if the perpetrator is so relevant and important? What do you do under this statute?
Yeah.
The second is the more frivolous side of it. There is a frivolous complaint, and like he said, vision. What do you do with this issue like this? And I think every statute is likely to be misused, but I think in a country and a democracy like ours, particularly in the constitution that we have, I think this is very important. The movement is very important, and it's here to stay. It must not be misused. At the same time, I think awareness is the key.
Yeah.
And I believe that however big you are in the organization, I think the responsibility is even larger. Stepping away from the organization is one part of it. I can tell you, in matters that we have done, it's been difficult to ask someone who's sort of raked the moolah and who's been a rainmaker to say, sorry, buddy, step away. This is the time for you to step away. And I must say that people within the organization and so many of, it was very strange. I had a very, very young company doing extremely well, an online company, came to me. And they sat with me. The complaint was against one of the co-promoters. And the boy really, the other promoter who was actually, at the receiving end in a sense, who was not involved with anything, said, look, I know we built this company together, but it's time for you to go. So he said, what's the value? He said, what value can I give you, because there is no value remaining. And I think these are some of the anecdotes that are there. And I think it's how you make that conscious decision, because value can be eroded in a second. And there were tangible complaints. Conversely, I had an issue where I had a very, very important person who had given his life for building the company and had to walk away and said, sorry, I can't do anything about it. So those are two sides of the coin. And I think those are versions that you will have to get. You have to put hand on heart and you have to make the decisions. So whoever is a part of the ICC, put hand on heart and make decisions. Necessarily, while we said that this is more like a civil court, I think these are matters where justice has to be more passionately given versus based only on evidence.
Yeah, I mean, this has to be a civil court with a very large heart.
Yes. And I must say this, even the largest court in this country, unlike what people think, justice is always delivered with a conscience and heart. And that's the oath that you swear on Constitution. And that's what even a Prime Minister or the President of this country does. And I think that's what you must do. Put your hand on heart, deliver justice to the victim, and please also do not succumb to frivolous complaints.
And
now,
sorry, may I just make one
Please,
last
please.
point? I mean, although it's not really an issue, but it's a nice circumvent or a nice protection. And I'm learning it like physically, seeing it in the current company where I work. Please improve your diversity. It works.
oh yes.
Because in my organization, there is a principle that we have market regions and we don't hire, we hire only women for our market region heads.
Okay.
So all our 7 market region heads are ladies. I don't know, it might be just a coincidence,
Arpita, it's
but it
strange.
seems to work.
Some people came to me and said that, boss, abhi chhod do yaar, main women mein log ko kyun hire karu? That is also the problem.
Yeah, but it's,
That has
I
also
think,
become a problem because the natural tendency seems to be now that, sorry, why should I hire women? And that's the
no, but
unfortunate part.
to that the answer is FabIndia.
Yeah, I'm
We are
saying
70% ladies.
that's correct. So I think that's why I'm saying in the context of what you are saying,
Yes.
diversity.
Yes.
I think do not be fearful of that. Implement it, and I don't think you can do away from this because women are here to stay, women are here to work, and I think they're more competent, I would say, as much, and I think that's the thing. Now I'm conscious of the time.
Yeah.
That gentleman had a question, so we're going to take questions, and Mr. Chhabra has been very silent, but he's happy to take questions if he needs to take any questions. Yeah. Sorry, can you speak up a little bit, please? Yeah, you want to go to him?
Yes.
Okay.
I have a small query in that act. Sorry, the act it says the employer will appoint an ICC committee. So who is the employer? Whether it's the HR department or the board members. Why I'm asking is, while appointing the ICC member, we are supposed to give an appointment letter or nomination letter. Who will sign on that nomination letter?
You want to answer that, Prasad?
See, the basic principle is whoever is an appointing authority is a disciplinary authority. That means after the effect of the whatever recommendation of the IC is, see, assume it is a termination or assume it is an exoneration, so it will be signed by the authority who is a disciplinary authority. And who is a disciplinary authority? This is appointing authority. Now in a company, appointing authorities could be different for different businesses, different locations, so it doesn't need to be done by a board member. But whoever is administratively responsible for appointment of employees in that particular location is a person who should sign the appointment for the IC.
It also generally covers in your POSH policy who the employer. For example, most of the companies HR head who the employer, but the report goes to the managing director.
Yeah, that's
So it's depending on the policy what you prescribe.
so I hope that answers. Any more questions? Sorry. Yes, please. Oh, he's there. Okay.
Hello. Yeah, Sumit Matre.
Can you just
from-
identify your name?
Yeah, Sumit
organization?
Matre from Aditya Birla Retail. My primary question is that the IC members are from the businesses, drawn from businesses, necessarily do not have the legal background. So in this background, in this backdrop, how is the committee competent enough to interpret the law and deliver justice? Now, taking this question forward, is it necessary and incumbent that there should be some minimum certification, like RAI is conducting certification for food supervisors. So is it required that a certain certification is required for the committee members?
So you want to take that, Jyothi?
I can respond the first question. I think whether as a policy in my previous group, we don't recommend any legal person to be in the ICC committee because as soon as they see the legal person, especially the junior level employee, they already get into a different mode. So what we do is within the legal department, there is one staff identified to support the ICC committee, and she has to give her only pure professional advice, nothing to do with the facts and circumstances. What is the procedure? How to draft a report either any interpretation issues. A lot of interpretation issues comes, you are right. We have seen so many issues of interpretation, even though the statute is only one with a very small 17 section statute and one rule. But the interpretation comes too much, areas where you need to do that.
But having said that, again, having said that, it's very important to train the members. You can't expect, lawyer to be there in every committee, because in a huge retail organization, when there are multiple establishments, where you require multiple committees and all, it becomes impractical to have even sometimes legal in all the committees. So I think, and there is a bounden duty of the organization to train, to create awareness and all of that. I think this is where the organization has to play a very active role in helping even whoever are the IC members to get the required skill sets. Because all the judgments or whatever the findings or the reports or whatever are the IC committee makes is not really assessed on the lines of civil procedure code. Basically, it's the natural justice and the principles of the general principles are taken into account. Only those aspects, whatever skill sets are required, I think it's very important to give them to these people so that they can deliver better.
Should organization like RAI take on the responsibility of imparting some certification?
I think they already saw some emails from RAI that they're ready to help. I think Gautam can. Yeah.
Sorry. Yes, please.
One is the extension of the query which you had raised, suo motu action to be taken. So it is just an extension probably, or I need further more clarity on it. As you said earlier, if a complaint is made, so what is the usual recourse? Either compensation or apology. And if the complainant, if the accused offers apology, is that the end, logical end to the case? So I feel, to my understanding, still, even if the apology is offered, IC committee's responsibility is to investigate and find out the sexual intent of the person. Yes. So I need clarity on this. Second thing, there is a case where a person, an employee in official capacity, is on tour or in the fields, and he happens to commit kind of offense with a person who is not an employee of that organization. Still, the person comes to the office and complains about him. Definitely the definition of workplace takes care of this query. But then I want to know how the statute takes care of the sexual intent of a person who is an employee of the organization and does something which is derogatory to the law.
So, Jyothi, you want to answer that?
Yeah, coming to, I think we explained that like anybody can be a complainant. He need not be connected to the organization, right? We said that. So even a customer who's just walking in, he doesn't even make a purchase at the retail store, and he undergoes an act of sexual harassment, can still file a complaint.
Yeah, but then in this particular case, the offense has not happened within the office premises.
But then that doesn't matter. The workplace gets extended, right?
Okay, okay.
So if it is in whichever place, wherever they meet, and the employee is discharging his duties in the connection with his employment,
correct,
and it is there the non-employee or the third person suffers, it does get covered.
Okay, fine. So that addresses this.
We'll take the last question.
This question is specific to Mr. Ameet. Strict interpretation of the law. Local, ICC local, at each bench, thousands of outlets are there. So I will have one corporate level committee with all as per the requirement of the law. Is it okay? Whenever there is a specific complaint, then I will constitute a committee to inquire into. Is it okay? Or to even receive the committee complainant, to enable the complainant to properly approach the independent member, there should be a specific committee at the local level as per the statute.
No.
What is the?
It's very simple. If there is an ICC in place, the complainant has to approach the ICC.
ICC is only at the one. Sorry? Thousands of outlets, ICC only at the corporate office.
No, I didn't understand your question. Sorry.
Does it require multiple ICC?
No, it has to be in every offices.
So I'll tell you what happens. If there are 1,000 outlets, you have the ability to go to your head office and raise the complaint. If you can't go, then you have the ability also to go to the local committee. The option must always be given to the complainant, and it is preferable that you go to your head office, because it may not be possible in every workplace, and the definition is very clear. In fact, I've taken an opinion of a very senior retired Supreme Court judge. We had this view that what happens if I have so many subsidiaries and so many workplaces? Can I go to the head office and make that complaint? Of course I can. That remedy is always open to you. But if you can't do that, you can go to the local committee. But they discourage people going to the local committee because it's bureaucratic. It's anyways, it's government.
And moreover, you have to notify the address from where this redressal will be done in every establishment which you have. If you have regional offices, then of course you have to have a committee there in regional offices. And this is how, I mean, the notification has to be done.
Just to add to what Pulin sir said, so it's basically the intent of the organization to make this redressal system available to the employees, right? So if it all depends, you know, using the technology today, the most advanced technology features today, if you have just one committee and ensure that all the complainant, wherever they are, they can reach the ICC, it's good. But then looking at so many practical challenges, it may be required to have multiple committees at regional levels so that, you know, people know that I can quickly access. And also it's very important that the complainant need to know who are the members of the ICC committee. So that's why you see under the law, you need to give the details of the POSH committee members, create awareness about them. So if they are somebody at a regional level, they can feel really connected, they are approachable. I think it's all about intent of reaching it to the employees than just holding out to say, hey, I've ticked it in the box, yeah.
So only one addition I want to do is law specifically allows use of a committee, I mean members of a committee who are not necessarily located at the place, at whichever is a workplace. So if you don't have, for instance, if you don't have a senior female employee to be presiding officer, the law specifically says that you can, for the want of right word, I'm saying borrow such person from another office or another business unit, and likewise. So there is enough flexibility that law offers you. Now, in spite of that, after having 1,000 establishments, if you think that it is possible for you to reach out and redress such grievances, it's a call that you'll have to take, but chances are that your efficacy will get compromised in having such a unitary structure for redress.
Yeah, I think one last thing that I wanted to say on this is that whatever you may choose, one committee or 10 LCs or whatever, all 1,000 LCs, just the whole idea is to make it very loud and visible to everybody and understandable, so that the person at the ground should know where to go.
So visibility and accessibility is the key. I must thank my panelists. I know we're running against time. Thank you very much. I think
Ameet, I have one question last to you.
Yes.
While you must be advising so many corporates with 1,000, 20,000 people, how you manage in law firms the POSH? I tell you why. Yeah. The recent episode in Bangalore, which I am sure you must have heard, where one of the intern was unfortunately died in alleged suicide. I mean, because of the alleged sexual harassment in one of the law firms. It's of course the public knowledge, it's in the paper, so I don't do nothing wrong in the naming. But especially because you have a very erratic working schedule, a lot of clients meetings, young and vibrant lawyers, outgoing, outspoken. So how you manage in a law firm?
Well, I can say this because I work with a lot of managing partners of different law firms. I think they take it up very seriously. I'm not, and I must say this, that I don't know how many law firms have really implemented it. I must confess that most law firms may have not even implemented the statute. It could be possible, and it may be possible. Having said which, I think, yes, it must be implemented, but I don't think many law firms have really gone out and implemented it. And I must say that. Yeah. But that's the reality. Yeah. That's what it is. But yes, should they implement it? Yes. Should there be a recourse? But 99% of the law firms already have a sexual harassment policy in place. And that's pretty much it. So thank you very much, everyone. And please enjoy the next session. Thank you.
Yeah, thank you very